Good morning.
Good morning, Your Honor. May it please this honorable court. Good morning, all. My name is James O'Connell, together with Philip Coppinger, who is on the brief and here with me today. I represent the interests of a retired Superior Court justice who served on the bench from September 2000 until late 2008, after this court made its decision that he was permanently disabled from performing the functions, the duties and responsibilities of the position of Superior Court Justice. The issue presented in the case is whether or not the Contributory Retirement Appeal Board, CRAB, abused its discretion in vacating the decision of the Administrative Magistrate of the Division of Administrative Law Appeals, DALA, awarding accidental disability benefits to the judge. The CRAB decision must be reversed. The CRAB decision is not based on substantial evidence. The CRAB decision is not based on any evidence at all. The appellant is permanently disabled as a result of a personal injury sustained and a hazard undergone while in the performance of his duties as a Superior Court judge. The appellant relies on the court's decision, this court's decision, adjudicating him to be permanently disabled.
That's really not, I mean, the CRAB didn't dispute the permanent disability.
There is no dispute regarding permanent disability.
So it's more focused on its connection to his work and whether, and I'm hoping you'll explain a little better because I don't think I totally understand about the combined psychiatric or psychological issues before this and this.
Well,
right? I mean, aren't those the two prongs on which the CRAB decision is based?
There's a stipulation that the board entered into that the judge was in good emotional health at the time of his appointment to the court in September 2000. There's a stipulation that he was in excellent physical and emotional health in June 2001. There's no dispute, there can be no dispute, that he was in good health, in excellent health, prior to the injuries that he sustained.
Well, the question is the efficient cause of the injury, as I understand CRAB's position, whether it was the printing of the articles, which they say really wasn't a job-related matter, or whether it was the threats. Right?
The administrative law judge addresses that very clearly, both in her summary of her decision at the beginning and prior to the stipulated facts, statement of stipulated facts. But I would refer you most particularly to page 267 of the record appendix, where the judge, the administrative law judge, states her conclusions. She says, in terms of the ultimate causation determination, I conclude that the findings made and the opinions of Dr. Ruttrick and Dr. Hoffman support a conclusion that it was the death threats, hate mail, and threats to his safety.
If the death threats had been received while he was at home, would that qualify as an efficient cause of his injury?
I believe that it would if he was acting in the performance of his judicial duties.
And while in the performance of his duties?
And while in the performance of his judicial duties.
If he was eating lunch and the death threat arrived at home, would that have qualified as an efficient cause?
If he was eating lunch and reviewing papers, reviewing pleadings, acting consistent with his duties and responsibilities as a Superior Court judge, the answer would be yes.
And what's the evidence here that he was actually engaged in his duties at the time he received, I don't know how many death threats there were, but all of them?
There were numerous death threats. The first, there's a specific finding that he received the first death threat in chambers in the Superior Court in Taunton, Massachusetts. He left the bench after a short 10-minute hearing. He went back to his chambers, and the death threat, the first death threat that he received, had been slipped under the chamber door. It is certainly reasonable to infer that having received that correspondence in his chambers in the middle of a workday, that he read the correspondence and had the reaction to it that he did have. The contortions that the board goes through.
What about the other death threats?
There's evidence, there's testimony and evidence that he received numerous death threats delivered both to his chambers in Fall River and in New Bedford.
Where is that evidence?
It's in his trial testimony, which this court had available to it when it rendered its decision, and its decision has been made a part of the record in this case.
Can I ask you, I'm sorry.
I'm sorry, is it in the record that was presented to the retirement board?
The decision of this court is in the record that was presented to the retirement board. We did not produce thousands of pages of transcripts. It seemed.
And does this, I just don't remember this, does the decision of this court specify where those were received, to the extent that it matters?
The decision of this court was that the findings of the jury in the trial court were supported by the evidence, by all of the evidence that was submitted to it. The appellant relies on the decision of the administrative law judge at Dalla. The appellant relies on the findings of the jury. The board relies on nothing. There is no evidence to support the decision of the board in vacating this award.
Can I ask you a question about the timing of these things?
Yes.
The threats were received when?
The threats were received after the publication of the
So can we
articles.
have a year for this?
I'm sorry?
A year?
Less than a year, a matter of weeks,
Okay, but, so we're talking about what year?
2002.
So 2002, the threats were received.
Yes.
And when did Judge Murphy leave the bench?
He ultimately left the bench in December 2008. He left.
When did he become disabled?
I think he becomes disabled when this court determines in August of 2008 that he's permanently disabled from performing the functions of the job.
So here's my question, and maybe there's a simple answer to this. Isn't there a statute of limitations issue here where, you have a 2-year period within which to claim accidental disability benefits?
There's arguably a statute of limitations issue here. It's not an argument that was raised by the board at any time in the proceedings. The State Retirement Board didn't raise the issue.
Is that a jurisdictional issue?
It is a jurisdictional issue, but I think the issue, one of the things that the doctors described in their examination of Judge Murphy is that he repeatedly experienced the death threats. He re-experienced the threats over time.
That's the post-traumatic stress.
Yes, as post-traumatic stress. And the board ignores the injury, the post-traumatic stress disorder. The board actually goes so far as to say that because the administrative magistrate said that Judge Murphy did not get over his post-traumatic stress disorder, that that's not consistent with the finding that the judge suffered from PTSD. It's acrobatics and we believe pure sophistry. It's an argument that's designed to support a preordained decision.
Is there any testimony that indicates that he would have been disabled by the threats alone?
My recollection is that the treating physicians, the two treating physicians, Dr. Ruttrick and Dr. Hoffman, concluded that the death threats were a cause of his PTSD.
Now,
There's no doubt, Judge.
but is it your burden to show that they were the efficient cause, that he would have been disabled even without the newspaper articles?
But he was not disabled as a consequence of the newspaper articles. He continued to serve as a Superior Court judge following the publication of the newspaper articles.
Well, the same can be said about the threats.
The same can be said about the threats. The fact is that...
What put him over the top?
Yes. I think that there's no question that the publication of the articles was a contributory factor here. And that's the person who then experienced the death threats. And the death threats and the hate mail did put him over the top, did render him disabled. And it ultimately resulted in his becoming permanently disabled, as this court found in August of 2008.
Counsel, if you prevail here, what's the rule going forward? I'm just wondering. We have judges who get death threats every day, unfortunately.
Unfortunately, and I believe that would satisfy the hazard undergone prong of the test. These cases, in reviewing the cases, it's apparent to me that these are fact-specific cases. The cases offer some precedential value, but it really is the responsibility of the board to take these cases on a case-by-case basis and focus on the facts. The board needs to bring its experience and expertise to the process. It has said that it does that, but it needs to do it not for the sole purpose of avoiding the award of pension benefits. It needs to bring that experience and expertise to determine whether or not an applicant is entitled to the benefits. The Dollar decision is thoroughly reasoned. It's fully supported by the evidence. It was a considered opinion, and the right decision was made by the administrative magistrate.
What, this is a gap in my knowledge, so you need to educate me. Do you both agree on the role or the weight that needs to be given to the medical panel, or are you in two different places? Because the board argues, at least as I read it, basically it can be almost ignored what the medical panel came up with.
The board has made the argument that the medical opinion can be ignored, and we acknowledge that it is an opinion and it is something for the board to consider. But it's overwhelming here. We have two unanimous medical panels determining that the judge satisfied the requirements to bring his application for accidental disability benefit. Two unanimous medical panels. We have two reports from treating physicians who support the judge's position.
No, I'm sorry, just as a factual matter, when you say two, I know it went back to was it a different group of people?
It was the same panel who affirmed the decision.
So it's one panel and two decisions.
One panel, two unanimous decisions, and two treating physicians. The board seems to rely upon a report prepared by a Dr. Gotil at some point in the proceedings. Dr. Gotil's report is plainly prospective. It plainly goes to the question of whether the judge was able to continue to serve in the function of the job and fulfill his duties and responsibilities in the job. Dr. Gotil, upon whom the board seems to rely, never answered the question about what the cause of the injury was, how the injury came to arise. It's also the case that nothing in that doctor's report is supported by any of the medical records preceding the injury sustained by the judge.
Didn't he believe that there was further testing required, that he couldn't come to a diagnosis on the basis of what he had gathered at that point, that further different kinds of tests were required?
He did make a preliminary diagnosis. He did suggest that further testing would be appropriate. There is nothing to suggest support for his preliminary diagnosis. And most importantly...
Well, other than his own examination.
His own examination of an hour and a half that has...
Well, the board was free to credit that, wasn't
Yes.
the board free to credit that?
Yes, and the court, I think, did credit it in making its decision that the judge was permanently disabled.
And aren't we in a position of having to review really what the board did? We're not really in a position to review what anybody else along the way did. And we have to give the board considerable deference.
Yes, and the board had the obligation to give deference to the decision of the administrative magistrate.
Well, not
absolute.
unless it had to do with credibility issues.
Well, I think that the decision of the administrative magistrate was entitled to some deference in any circumstance. If there is an issue of credibility, the decision of the administrative magistrate is entitled to a greater degree of deference than was afforded. But the board here afforded no deference. It gave
Mr.
no
O'Connell,
credence.
your time is up, but you can finish up, wrap it up if you'd like.
Judge, thank you. This family has suffered enormously over a long period of time. They've waited 4 years, almost 4 years, to get to this day. And we respectfully ask that you reverse the decision of Crabb and that you award this judge his pension. He earned it.
Thank you.
Thank you.
Good morning, Your Honors. David Marks, Assistant Attorney General for the Contributory Retirement Appeal Board and the Board of Retirement. The slate we write on today has been covered in many cases, both issued by this court and by the appeals court.
Let me ask you this, though. Is it really the board's position, assuming the threats were the efficient cause of the disability, and the threats were pretty awful, assuming they're the efficient cause, is it the board's position that it depends on where he physically received them as to whether or not it's in the performance of his duty?
It is the board's position, first of all, to be clear, that the plaintiff, who had the burden to prove by a preponderance of the evidence that he was entitled to these benefits, he did not produce sufficient evidence.
Of what?
So,
Of what?
Of what?
So on this point, the board says that he did not produce sufficient evidence that he was in the actual performance of his duties.
So he's sitting in his chambers.
Yes.
But it's a break in the proceedings, and that's not in the actual performance of his duties?
That's right.
He's got to be sitting on the bench?
The case law, and this court...
Are there any cases involving judges?
I'm not aware of cases involving judges. In this court in 2009, in the Salem case, specifically said that the plaintiff has the burden to show that the disabling injury is sustained during the performance of work duties and not merely as a result of being at work when injured.
So
This is not a result of being at work. This is a result of something one does. Judges make decisions, okay? As a result, serious threats received against the judge and the family. And you're telling me it makes a difference as to whether or not he is physically in the building when he receives them, or in his home, or on his cell phone. Between the two, it makes a complete difference?
What it makes a difference is what he is doing at the time he sustains the injury.
There's quite a bit of difference between the jobs of the plaintiff in the Salem case and what a judge does, don't you think?
Well, yes, there clearly was a difference. But page 98 of the record is a description of the judge's duties. And without regard to how different the duties are,
Well, it goes to where you do them. It goes to where you do them and in what time you're doing them.
Ultimately, it's a question of what he was doing at the time he sustained the injury.
All right, let's assume this
All
is
of
not
the
a threat.
cases-
Let's assume this is an assault
Yes.
by a disgruntled party or someone who's very unhappy having read the judge's decision. He assaults the judge as the judge is coming onto the bench. That's different than if he assaults the judge as he's walking down the street coming to work?
Yes.
One is in the performance
That-
of, and the other is not.
That's right.
That's remarkable.
That's right. That's remarkable.
That's remarkable.
And that is the way the case law distinguishes these cases.
Well, but maybe it hasn't encountered a case like this on the hazard encountered prong. I mean, the judge's job is more than the discrete acts of which make up a judge's job. It's more than the opinion. It's more than opening a book to research. It's more than sitting here. It's writing, reading, thinking. It's doing a lot of things that more than being in the building or sitting on the bench. And the hazards encountered are a result of doing that job, and whether you render an opinion from the bench or in an opinion, in a written opinion, they're experienced by someone reading them, and then they often, sadly, result in physical as well as oral or written threats. That's the hazard encountered. We encounter those hazards not necessarily while we're sitting here, but sometimes when we're walking home or sometimes when we pick up the phone at home. It's a hazard of the job.
Well, two things about that. First of all, you're not performing your judicial duties, usually, 24 hours a day, okay?
Well, so I'm at the supermarket, and I'm reaching up for a box of cereal, and I get an idea. I pull out a piece of paper and a pencil, write it down, and somebody delivers a death threat to me. Am I in the performance of my duties?
Well, I think that, you know, the factual circumstances are something that the Contributory Retirement Appeal Board would have to decide based on all of the evidence. The problem with this hypothetical, Your Honor, is that by virtue of the nature of the job, as you say, judges think all the time, and you could be thinking about one of your cases while you're grocery shopping. The problem is that the case law very strictly reads this while in the actual performance of the job
Yeah, but
duties requirement.
If I understand correctly, putting aside the grocery store or being at home, you say it doesn't, even if it's during the work day and you're in court, that's not enough. You've got to be on the bench?
I say there was not sufficient evidence here to show what he was doing.
I take that point, but
At
what
the
would have been
time.
sufficient evidence in these circumstances? Because, okay, so if it's where he received it, and then he sees an envelope, and he says, I am really too busy right now to deal with this. Let me put it in my briefcase. I'll take it home. So that's one question. On the other hand, if he's got to be engaging in work, and it's okay if it's not on the bench, let's say he's in his chambers, and he opens it there, is he engaging in work when he's reading a non-related, according to you, something that's not work-related? The threat is not itself work-related, even though it's perhaps a hazard which occurs as a consequence of the job, and he's engaging in the hazard because he's reading it. That's one way to look at it. But under your interpretation, the very act of reading it is not work.
Well, again, I need to respond to at least two parts of that question. First of
Yes,
all,
there were two parts.
the hazard undergone prong, as we argue in the brief, was not raised and litigated before either Dalla or the Krebs or Krebs. The plaintiff specifically argued that his case involved a personal injury, and I cite parts of his memos in which he says that. And Krebs took the Dalla's decision to focus on the personal injury aspect. Hazard undergone requires proof of an element, that is that this is something that that is not common to all or a great many occupations, that Krebs has to take evidence on and apply its expertise on. The appeals court's Fender decision talks about that, how it's appropriate for Krebs to exercise its expertise on the question of whether this is something that would be expected to happen in all or a great many occupations. On the question of I may have forgotten the second part of what I'm addressing, but the question, the fact that judges may be doing work at any time during the day, you know, makes the case a little difficult.
Well, I was
The
focusing now on the
problem here-
courtroom and receiving a threat under the door, as was
Right.
maybe found, and then opening it later, as compared to taking it, receiving it at home and bringing it to work and reading it there. What's the
Right.
difference?
The problem here, first of all, is the lack of any evidence. The only evidence in this record, Judge Murphy produces his trial transcripts of his testimony at his defamation trial and he attaches it to his reply brief. You cannot consider those.
The-
Those were not in the record before Dalla or Crabb.
Let me ask you a question. I'm getting a little confused here about, I mean, there are different things that the claimant has to prove, and I just want to be sure that I understand what the board's position is on what Judge Murphy didn't
There are two things, primarily.
You agree that he's permanently disabled?
Yes.
You agree that he had a personal injury?
I guess we agree he had a personal injury. The question
And so
is,
you don't need personal injury and and both personal injury and hazard undergone. You just approve one of those things.
That's right.
And so we've got personal injury.
Question is,
And
under
did-
what happened? Where did...
And did the personal injury come about as a result of his work duties? You don't really seriously contest that in your brief. It says, it certainly appears that Judge Murphy sustained his injuries as a result of his
It
duties.
seems to have been related to his judicial...
Okay, so that's not really in dispute.
Right.
What seems to be in dispute, the point of contention that I'm hearing is whether or not it was in the performance, in the performance of his
That's right.
duties,
It
right?
has to be
And you're
in
saying
the
it was
law.
as to that aspect that there was not sufficient evidence.
Correct.
And you're saying that well, let me ask you this, if the transcript of the trial had been before Crabb, would that have constituted sufficient evidence that it was happening during the course or in the performance of his duties?
No, and this is the answer to your question, Judge Duffley. What he presents on the boxes of death threats and hate mail, setting aside the one that was slipped under the door, setting that aside, he also says that a court officer delivered boxes full of envelopes that ultimately contained death threats and hate mail. That's it. That's all it says. So we say, that's not enough.
Why not?
What was he doing when he opened all those things? What made him
delivered
think?
at the courthouse? Is that where the...
They were delivered,
presumption?
according to his trial testimony, they were delivered to his chambers. That's not enough.
Well, let
There-
me ask you, wouldn't it be a reasonable inference that upon opening, that the process of opening the mail would be something that he did during the performance of his duties?
Yes.
And therefore, he opened the mail at the courthouse?
Yes, but. Yes, it is a reasonable inference that if a piece of mail addressed to a judge comes into chambers and he opens it, that is in the performance of his duties. But that's not what happened here. There were boxes of mail, and there was no evidence as to why all these boxes of mail might be coming in. So, for example, we want to talk about hypotheticals. If the judge was engaged in deciding how to sentence a criminal defendant, for example, one might expect correspondence, even from members of the public, regarding how to sentence that person. So, one would understand a judge to be opening perhaps boxes of mail. But there was no evidence whatsoever about what the circumstances were under which he was opening envelope after envelope after envelope in two, three, or more boxes of mail.
Let me flip it over on you. Isn't it reasonable to say that if a judge receives correspondence and does not open it, that the judge is not performing their professional duty? That you have to open the mail that is directed to you?
Well, I don't know if that's true. I mean, I think in this case, where boxes and boxes of mail had come in, especially since he had just gotten a death threat, he did not have to open
So
all that
it's
mail.
his fault?
And there was no reason. It's not a question of whether it's his fault. It's simply a question of what did the evidence show he was doing at the time. Was he doing it because he
Or
felt
what were
it
the
was in the
reasonable
performance?
inferences? Or what did the evidence show, or what were the reasonable inferences?
All the evidence showed in this case was the one line from this court's opinion that said the first death threat was slipped under the door of his chambers. That's it. That's all the record shows.
When you say
And his testimony before Dalla that he received perhaps hundreds, 1,000 death threats, hate mail. That he doesn't even testify where he received them.
Wait, I'm
That
sorry.
is
You
the-
said he testified before Dalla, that he
He
received
did.
hundreds of... Hey, I thought you said the only evidence was the sentence in our opinion. Is that the only evidence of where?
That's right. That's right.
Okay,
There's
but there
two
was
pieces-
evidence before Dalla that he received hundreds of
That's right.
threatening pieces.
He testified to that, but he
And
didn't
where-
testify.
And where was the evidence that you also referred to that court officers delivered?
That's in the transcript of his trial testimony at the defamation trial, which he presents in his reply brief, that is not in the record before Dalla, which you can't consider anyway.
Could I ask you, switching to the medical?
Yes,
issue,
please.
Are you saying that essentially, that in this arena, one does not apply the rule of you take the victim as you find him? Because, in other words, if somebody starts with some psychological problems and then something else happens that renders him disabled, that won't do because part of the underlying situation are the psychological problems that were pre-existing? Is that?
No, that's not what I'm saying. The case law is pretty clear that a personal injury sustained for these purposes could be as a result of the exacerbation of prior pre-existing injuries. That's not at all what we're saying. What, if I may have...
I want to give you the same courtesy I gave your brother. I let him finish up.
I'll try to be very brief. The legal test has been variously stated as the permanent disability has to be the natural and proximate result of the personal injury. The personal injury has to have been the efficient cause of the permanent disability, and that the personal injury has to be more than merely a contributing cause. And I think ultimately what Crabb decided was that all of the medical evidence looked at all together. Crabb didn't really say we believe or accept one over another. It accepted all of it, but it looked at it and said ultimately there is a failure of proof that the death threats and the hate mail, especially given the passage of time from 2002 to 2008 or 9, especially given Dr. Gutheil's analysis, that given all of that, ultimately the plaintiff had not proven, by a preponderance of the evidence, that the permanent disability was a natural, direct, rather proximate result of the death threats and hate mail.
Thank you.
Thank you, Your Honor.